At least one out of every 4 people in the United States have at least one disability. 17 states now have filed the lawsuit against the U.S. Department of Health and Human Services that seeks to dismantle Section 504, the ADA, and to discredit the Olmstead decision, with a goal of returning this country to the days of long-term institutionalization. And they are using the trans population, a much smaller population, as an excuse to do this. There's apparently no limit to the depravity of those filing these suits. I'm Annette from Nothing Without Us, Stories and Discussions of Meaningful Inclusion. I am a 70-ish-year-old woman with short gray hair and blue eyeglasses, and I'm sitting in a power wheelchair. Today I'm wearing a pink sweater and I have blue earrings. If you like these episodes, please subscribe, leave me a like and a comment, and please tell your friends. I am coming up on my 1-year anniversary, and it would mean so much to me to have 100 followers. You can subscribe for free. There are paid tiers that have extra benefits, but that main series is available for free. So back to this lawsuit. It was filed by the state of Texas and 16 other conservative states, and it's filed in the same federal court that previously banned the use of the medical abortion pill, mifepristone, for the entire country, and has also ruled against Section 504 in the past. While both rulings were eventually overturned by the Supreme Court, it seems they are persistently evil and determined to keep moving forward on this. This suit starts by saying that members of the trans population were always excluded from Section 504, which requires equal opportunities and equal access to persons with disabilities in all facilities and institutions that receive federal funding. The ADA does the same thing for all of those facilities, but they don't also require federal funding, so it really applies to businesses and almost every organization possible. The Olmstead decision requires people with disabilities to be allowed to live in the least restrictive integrated settings. In other words, you can't be institutionalized if you can be treated in the community. So this lawsuit conflates the diagnosis of gender dysphoria with being transsexual. Gender dysphoria, which can be a disability, is the significant psychological distress experienced by those whose body does not agree with their identity. It does not mean being trans, but rather not having settled the integration that's needed to live as their true selves, or the discrimination they receive, even once achieving this integration. This suit claims that including gender dysphoria as a disability is a violation of the First Amendment rights of cities, states, and organizations that receive federal funds. Have we heard this before? Of course, it doesn't stop there. It goes further to say that Section 504, which allows persons with disabilities to participate in programs and employment without discrimination based on disability, doesn't require the entities that receive these federal funds to subordinate their own policies and fiscal judgments to the federal government. Uh-oh. In other words, you can't discriminate against people with disabilities, but you don't have to change what you're doing just because we have a law. Oh, this is not sounding good. The ADA provides persons with disabilities the same freedom from discrimination as Section 504, except that it's not tied to federal funds. The ADA defines disability as a person with a physical or mental impairment that substantially limits a major life activity, or a person who has a history of such an impairment, or a person who is perceived to have such an impairment. So here's where it gets complicated. This lawsuit lumps transvestism and transsexualism with the criminal behaviors of pedophilia, exhibitionism, etc., referring to them all as purely mental impairments that are not protected categories. The problems with this are, one, mental impairments are covered under the ADA, but criminal behavior is not. Two, transvestism and transsexualism are neither criminal behaviors nor actual mental impairments in and of themselves. And three, gender dysphoria is a mental impairment that may be covered under the ADA in the case of discrimination. So the suit goes further in its complaint that states that in states that choose to participate in Medicaid, a health insurance program for needy individuals, is based on a medical and institutional care model and not a community-based model. And that CMS, which is the Center for Medicare and Medicaid, that does all the regulating of this, it requires that waivers to provide community-based care be cost neutral. In other words, it can't cost more to provide the community-based care than it does to provide institutional care. So this argument goes even further to say that without the evidence to support it, that states that cannot afford to provide community-based care because it's cost prohibitive. If that were held to be true, it would bring the status of persons with disabilities back to the 1950s, where institutionalization was the only alternative. And that would be a real travesty. But these people keep going back to say that including gender dysphoria in the protections against discrimination is contrary to the original exclusion of gender identity disorders in the ADA, as defined in the DSM-3. However, advances in medical understanding, and we do advance all the time in knowledge and diagnoses, treatments, and understanding what causes what. These advances in medical understanding, the ADA removed gender identities from the DSM and included gender dysphoria to the DSM-5. So you see there's been some time in there. This was a diagnosis that didn't exist in 1990, so it couldn't be explicitly excluded, nor could it have been excluded in 1977 when Section 504 was written. So the Fourth Circuit Court, which is a different one, in 2022 agreed that the new information means gender dysphoria should be included, not excluded. So now this suit in the Fifth Circuit court claims that the Fourth Circuit got it wrong. Well, gee whiz, too bad our laws are so unclear. But at any rate, they go on and on about that, using this issue as the basis for the rest of their claim. So HHS, the Health and Human Services, in its final rule, requires that persons with disabilities be given the opportunity to be in an integrated setting, enabling us to interact with non-disabled individuals to the fullest extent possible. Individuals should be given a choice about their daily life activities. Gee, just like real people, right? This suit claims that this is practically limitless and leaves no choice for recipients of federal financial assistance. It even picks apart the Olmstead decision, saying there is no requirement to provide a new program if none exist. So while they go on with their argument about the final rule, Olmstead, etc., it finally comes out that their problem is really, yeah, there we go, is really the problem is to the obligation to provide accommodations to those with the diagnosis of gender dysphoria. including segregated bathrooms and locker rooms, and exceptions to their dress and grooming codes. This is the reason for all of this suit, or at least it's what they're saying it is. Their refusal to accept that a trans man or woman can dress and groom according to their true selves. It's just mind-boggling. So they cite, and this is even it, yeah, I'm not going to say any of this is sensible. I'm just telling you what it is. They cite substantial costs and injuries on the included states, the 17 on the list, to accommodating the trans population. And remember, the trans population is a very, very small population. The disability population, on the other hand, is at least 1/4 of the country, which is a real big population. So some of the states claim that using preferred pronouns is an infringement on the First Amendment rights of free speech on the states. Oh my God. Oh my gosh, that's like, huh? Others claim that they would have to fundamentally alter systems, programs, and activities if they have to include this population. I don't know, it really gets worse. I hope I got most of my indigestion over with while I was writing this up. So they are using this argument now to require that Section 504 be declared unconstitutional. Now remember, Section 504 it is a real important part of many lives of people with disabilities. So when the ADA was passed in 1990, there were many similar, not related to gender dysphoria, but the cost of accommodating people with disabilities, but there were many similar lawsuits brought. All of these lawsuits were focused on whether the individual claiming discrimination or accommodations was qualified under the ADA. That means, were they really disabled enough to be discriminated against? And these lawsuits did not focus on the act of discrimination, but instead on whether or not the person with the disability was qualified. And in 2008, Congress passed the Americans with Disabilities Amendment Act to send a message to the courts that the ADA is civil rights legislation and was supposed to be interpreted broadly. That's an intent. And so the intent of this, Amendments Act was to have discrimination claims focused on the acts of discrimination rather than on whether the individual making the claim was disabled enough. By the way, both the ADA and the ADA Amendments Act were signed into law by Republican presidents. The ADA by President George Herbert Walker Bush, and the ADA by George W. Bush. So, this is not a Democratic initiative here. The courts need to remember, though, what that intent is. It's civil right, and it needs to be interpreted broadly, and the courts need to act accordingly. The effects of Section 504, the ADA, and the Olmstead decision have been to allow persons with disabilities to live in the community, receive educations equivalent to those without disabilities, to work, and to contribute to society. The number of adult professionals who have succeeded because they had access to 504 accommodations in school is huge. People with disabilities who are employed pay taxes, buy goods and services, contribute to the economy. Most live life to the fullest extent they are able and are healthier than those who have been confined to institutions. So institutionalization is really costly. So this kind of lawsuit, first of all, demonizes the wrong people. And it's those who file such suits that have reached a depth of depravity I never imagined could exist in this country in this day and age. That is what we have to stop before the damage is irreparable. We are all in this together. So thank you for listening. I'm Annette from Nothing Without Us, stories and discussions of meaningful inclusion. If you like this episode and want to hear more like it, please subscribe, leave me a like, make a comment. I do read them all. Above all, please tell your friends. I'm trying to reach 100 members before the 1-year anniversary next month. So tell your friends they can see this podcast at patreon.com/nothingwithoutus or on YouTube and on Spotify and your favorite audio platform. You can find me on LinkedIn and Blue Sky. While subscriptions are free, you can see my new sub-series, Bitch on Wheels, on the ally or activist tiers. This sub-series is a little edgier, maybe sarcastic, angry, and sometimes even a little humorous. So until the next Nothing Without Us, I'm Annette Bourbonnier.